Hello friends. Today we are going to discuss about the Digital Personal Data Protection Act 2023. What are the compliance a clinical establishment should fulfill under this legislation, and also what the doctor should know. I am Dr. Suresh Badadmat, Professor of Psychiatry, working at National Institute of Mental Health and Neurosciences, Bangalore. In this video, how to make your healthcare establishment, the hospital, the nursing home, or the lab, the Digital Personal Data Protection Act 2023 compliance. That means what are the things you should do, you should not do, and the practical tips for making DPDP Act compliant healthcare establishment. In the current contemporary world, there are numerous actors are coming between the doctor and the patient. As you see, there are various medical devices, internet service provider, cloud services provider, insurance company, medical device, electronic health record, medical transcription people, pharma industry, and bank. So these are the various people, they are coming in between the doctor and the patient. Invariably, they need to access healthcare record to provide insurance, to provide healthcare through medical devices. So in this scenario, there is high possibility the confidentiality data can be breached. In such a scenario, what is the role of the doctor? Or else, what is the accountability of the various stakeholders? In this regard, there are various laws have been made across the world. One of the best is HIPAA compliance, which is from the US. But however, in India now we have DPDP Act, that is the Digital Personal Data Protection Act 2023. In this, data principal means the person who owns the data, that is his data. From the healthcare industry, the patients are called as data principal. The doctors and the clinical establishment who collect the data are called as data fiduciaries. And if the data is kept in somewhere, stored, analyzed, they are all called as data processors. Business associates are those like health insurance company, medical device company, CT scan, MRI, who collect the data from the patient or from the devices. And finally, the contractors and subcontractors, such as the people who provide computers to the hospitals, internet service provider, banking. So these become the contractors or subcontractors. So all these people needs to be made accountable if there is a data breach occurs, or else the patient's confidential data is leaked into the public forum. So here the online security and physical security plays a crucial role. In this regard, if you look at the HIPAA from the US, 1 in 7 healthcare organizations have still not appointed HIPAA compliant officer. This is a old legislation, more than 25-year-old. Still, in US, the compliance is still struggling. 1 in 4 HIPAA breaches are not yet reported till date. 50% of the healthcare organizations believe that they would fail in HIPAA audit. Average cost per person, per record, per year will be around $363 without even seeing the patient. That means to secure the patient's data, this is the cost. Further, 80% of the healthcare organization fail in HIPAA audit. The commonest being unauthorized access of the records. Nowadays, the people are hacking through phishing and ransomware is very common. And nearly 200 million patient records are computerized at this point of time. Let's see and learn from HIPAA violations. What are the commonest violations? First and the foremost is the hackers. They have learned the data is gold. Specifically for health records, if they are able to hack those health records, and the fine they need to pay for the government is huge. Hence, hackers will demand money to say that we are to secure the data and give it back to the hospital. Many a time, incorrect admission administrator procedures, inefficient people are hired who do not know about computers, insufficient IT security measures. That means the people who do not know about computers, security measures are hired to look after the computers, and they are unable to play a crucial role in securing the data. Many a time, the disgruntled employee may release the data or delete the data or breach the data. That means these employees who are working in the healthcare professional industry or in the clinical establishment, once they become angry with the owner of the hospital, they may resort to take revenge by releasing the data. Accidental disclosure of the patient's data to the public or in the social media. Business associates disclosure. That is, if, for example, a nursing home has hired a cloud services to keep their data, this cloud services may release the data, analyze the data, or may do unethical things, and this may cause breach. Unauthorized access of records, a third party seeing this health record, unauthorized access by third parties. Many a time the devices are stolen, especially the laptops of the doctors, or they are lost during the airport transit, and the data is retrieved by a third party and they may release the data into the public. And finally, the improper disposal of these hard disks or the patient data. All this causes HIPAA violation, and the huge amount of fine has to be paid by the healthcare professionals to the government. In this regard, in India, the Digital Personal Data Protection Act 2023 was implemented. 11th August 2023, the Parliament of India notified this legislation. It has 9 chapters, 44 sections, and 1 schedule. This schedule dictates the penalty. So here you can see the number of chapters and the section. I have made a separate video regarding this DPDP Act. This act was implemented with simple 2 important principles, or else called as objectives. One is right of the individual to protect their personal data. That means every citizen in India have a right to protect their own data. That is one. Second, the need to process such personal data for lawful purpose. That means an individual has a right to personal data, but at the same time, the government also can process the personal data of the person by lawful means. That means if there is a legislation telling that to get services from the healthcare free of cost, the patient need to tell his data, his name, his demographic details, his income. That data will be utilized. How many people have received free services? So legitimate use, lawfully, is the 2 important things have been proposed under DPDP Act. Further, on 13th November 2025, the rules was also notified, and clearly they talked about enforcement. That means this legislation will come into force in 3 phases. The first phase will come immediately. The second phase will come from the 1 year of notification from this rules, and the third one is from 18 months from notification, that is from 13th November. That means that 18 months means 13th May 2027. All clinical establishments, nursing homes, hospitals, doctors, OPDs, if they are having a digital data, they need to comply with DPDP Act. If not, the fine is only 250 crore rupees, my dear friends. So how to go about DPDP compliance is the question. To be compliant, you need to know the rights of the data principle. That means the rights of the patient. They have certain rights. Right to access their information, that is personal information. Not only that, who is the fiduciary, who is the processor of the data, where it is stored, how long it is stored, who has access to this data, what kind of analysis is done. So that right to access and know about this data is there. Right to informed consent before the data is collected. That means the patient has to be told by the informed consent manager, telling that these are the data are taken for what purpose. Further, right not to disclose to any third person without the consent of the patient. Right to correction and erasure if there are any mistakes. Right to grievance readdressal mechanism should be there so that the patient can tell my data or my data has been misused and he can give a complaint. And also, if the patient loses capacity, he can nominate his family members, friends, relatives, or anybody. They can, in his absence or in his incapacity, they will be able to take the responsible decision with regarding to data. Not only the rights, there are duties towards the data principle, such as the patient cannot impersonate any other person. If they impersonate, that means 10,000 rupees fine can be applied on them. Not only that, they cannot suppress any material fact information while providing personal data to the fiduciary or to the government. Refraining from filing false complaints against the data fiduciary under this legislation. Further, follow the law when they exercising their rights. Provide only verifiable information when information is requested under DPDP Act. Now let's enter into the important topic, the DPDP Act compliance. That is the Digital Personal Data Protection Act compliance, how it is done. What are those important 12 steps you need to know? Step number 1. Once this legislation starts kicking, you have to be very clear. Where is your data? That means you need to start doing about data mapping. Here, the data mapping means it is the process of identifying how the personal health information or the personal health data of a patient enters into your system, that is the network, where it is stored, how it moves through your organization or network, and how it is shared with external entity. That means you take a patient's data when it comes to your OPD, who registers him, who is entering the data. From there, the doctor enters the data. What does the nurse enters? What does the pharmacist does? When the billing occurs, who is going to enter the data regarding the billing? When the patient goes to the ward, what is the data which the nurse will enter? What are the data transmitted to the health insurance? And if the money has to be paid, the banking sector, what is the information sent? So you need to completely map the data. So robust mapping includes what are the data collected in your organization, what are the entry points, registration, entry by the doctors, nurses, lab technicians, pharmacists, dietitian, psychotherapy, referral. So all the people who enter the data, who access the data, who edits the data, who deletes the data, where it is resided. Is it in the server, local server, or maybe in the cloud? Who is the service provider? What kind of agreement you have regarding the providing of services? What are the indemnity? What are the liability? What are the compensation? What are the penalties? How the data flows? Who has access? Who has view? Who can entry? Who can edit? Who can print? Who can bill? Who can scan? So that you need to know. And finally, how the data exit from your institution to various other entities, subcontractors, contractors, or business associates like insurance company, pharmacy, government, where you're sending some notifiable information, referrals. So this data mapping has to be done. Once you know what is the data is collected, where it is stored, you will be able to control. If you do not know what data you are capturing, where it resides, who is entering, who is able to view, you will not be able to control. Hence, the first step is data mapping. The second one is data privacy, security, and safeguard. What is data privacy? Data privacy means the patient's confidentiality of the data. That means in your hospital, there are around 30 doctors, around 80 nurses, 30 lab technicians. Here, one's patient data should not be shared with other doctors. That means no unauthorized person within the hospital can view the personal health data of a patient. That means if a Dr. A is treating Mr. B, no other doctor should be able to see the patient's data, that is Mr. B. So that privacy has to be maintained. Only during emergency and continuity of care, others are authorized to see the data. By chance, somebody else sees the data. Who was logged? Why did they log? What are the data they modified or they entered? What are the data they deleted? Has to be captured. That is data privacy. Data security means the whole complete data of your hospital, how it is secured, using what kind of software, what kind of hardware, what kind of antivirus, firewall, latest software. So that complete ecosystem of protecting the data, complete, that is data security. Finally, the data safeguard. Who can physically access the computers in your hospital, the server, if it is resides in your hospital, who can get into your network, and also proper CCTV monitoring of your whole hospital, and making sure nobody else, unauthorized people, can access your computer or your hospital computers. Third, obtaining consent before taking the data. This has to be done by a consent manager. As per the DPDP Act, all people who are clinical establishment who take very sensitive, significant data, they need to hire a consent manager. The role of the consent manager here is to secure informed consent from the patient. What are they supposed to do? They need to get the consent by the patient regarding specific issue why they are collecting the data, inform how much data is collected, and how it can be revoked. Further, they also need to give information why such data is collected, where it will be stored, how it will be processed, how long it will be kept, and what are the rights under the DPDP Act for the patient. Further, they also need to talk about legal obligations of the data fiduciary, that is the hospital, and also they lose their rights in emergency situation. The data will be forwarded to the doctors who are treating without taking any consent, and in the public interest. So this data consent is very essential and has to be on case by case, need to be discussed. For that, the consent manager needs to be hired. Moving to the fourth important, training of all the employees and staff of your hospital. Every staff, paramedics, allied healthcare professionals, billing staff, support staff, doctors, nurses, anybody who is going to enter the data, who is going to view the data, who is going to share the data, all those people needs to be trained periodically. That means regular and periodic training of the staff with regard to DPDP Act, what should be the minimum data they should capture, what is the access policy, no sharing of data, not allowing anybody to access the computers, no sharing of password, not to bring personal USB devices, and also not to open unauthorized websites in the hospital computers. Fifth, disgruntled employees. There should be SOPs in place in dealing with the disgruntled employees. They may delete the data, transmit the data, share the data, or sabotage the whole data. Hence, there should be a proper mechanism. Clearly, the doctors or the in charge of the hospital should be on the alert whenever there is a employee who is disgruntled and he is going to sabotage. Then all precautionary measures has to be taken and segmentation of the data has to be done so that any kind of sabotage occurs, it occurs in the only one segment, not in the whole data. Further, non-disclosure agreement has to be signed by the employee when he gets into the job, and a proper training has to be done. And whenever there is a disgruntled employee, he needs to be sent for training again, and access to all computers and data needs to be restricted. Sixth, very important, stolen and lost devices. If you look at the HIPAA compliance, the majority of the HIPAA violence, HIPAA violation occurs whenever the doctor, nurses, their laptop, their computers are stolen or they are lost by the healthcare professional. In such a scenario, that data will be accessed by a third party, and this leads to HIPAA violations. Hence, mechanism for remote data wiping should be enabled in all the devices, and one need to make sure patients information should not be stored in the doctors or the nurses devices, and it should be within the hospital. And SOP should be made whenever the devices are stolen. Suppose if there is a celebrity or a VIP, patient's data is stored in your hospital. That means all personal health data of the VIPs, celebrities are very sensitive. Social media or else the regular media, newspaper want to know about the celebrity. In such a scenario, a employee of your hospital may take a photograph of the patient or else make a copy of the celebrity and transmit to the newspaper, and you may have to pay a huge amount of money. Hence, in case of celebrities, employees need to be trained in dealing with the data and be very sensitive and secured, and should not take any photograph without taking the consent of the celebrity patient, and not to upload in any social media. That kind of proper training has to be done, and utmost care has to be given with regard to celebrity and VIPs personal health data. Further, single window clearance has to be done, because the data principle or the patient has right to access their personal data. Whenever the patient comes and asks for his data, there should be a single window clearance, an application has to be placed, and his ID has to be revealed. Once the ID is verified and the data is retrieved, and you need to cross match whether it is the patient's own data and the person who is standing is the patient, and only such person the data has to be revealed. And no personal health data should be revealed to any third party without any clear cut instruction from the hospital authorities or from the legal authorities. Hence, a single window clearance with checks and balances has to be there. By unauthorized disclosure of file to somebody else should not happen. And also there should be a mechanism to inform the data breach. By any chance, if there is a data breach, it can happen. Under the DPDP Act, whenever there is a breach occurs, it is the duty of the data fiduciary immediately to inform all the data principal patient that the data breach has occurred, to what extent, what are the repercussions, and the same information also should be shared with the Data Protection Board under the DPDP Act. Hence, to inform the patient's email, phone number, any other means of contacting has to be available within your database, and they need to be immediately informed. If you don't inform, you have to pay 200 crores, my dear friends. Further, all significant data fiduciaries like healthcare professionals need to hire a data protection officer. Here, this DPO will ensure the data safety and check if there is any data privacy laws are followed or violated. Hence, the DPO, that is Data Protection Officer, will ensure the data safety of the patient, compliance with the privacy law, security, legal and ethical practices within the institution, technological expertise, cross functional engagement, and privacy issue resolution has to be done by the DPO officer, my dear friends. So these are the important function the DPO should do. Further, regular data audit has to be done. Audit must cover the entire data life cycle. That is, how the data is collected, how it is entered, how it is processed, where it is stored, when it is shared, retention, and deletion. This includes clinical and administration health data, billing data, digital and physical health records, telemedicine platform, EMRIs, AI tools, third-party processor, and vendors. All these regular data audit has to be done. If there are any weakness or breach is seen, it has to be intimated. Annually, it has to be done. If required, periodically has to be done. The 12th, reasonable care has to be taken in choosing appropriate business associates, contracts, subcontracts. What does it mean? The hospital will have business associates, maybe pharmacists, health insurance companies, medical device companies, the people who supply computers, supply various devices, and they may come for cleaning the AC. There are various people who will be associated with the hospital. Hence, before you have a contract with them, you have to be very careful. Before you outsource any kind of work to a third party, you have to make sure they are DPDP compliant. Please understand, you may own the hospital. You can outsource the data processing, but it does not outsource your DPDP liability, my dear friend. Hence, a reasonable care in vendor selection has to be done. Proper agreement should be made, which is legally enforceable in the court of law. And if there is any breach, accountability is mandatory, should be done. Hence, proper legal agreement is the way to go, my dear friends. If you are going to hire any health care, electronic health care recorder, or a person who provides services for EHR, a proper legal agreement has to be signed. If there are any violation from their side, they will be held responsible. Those kinds of clear-cut important information has to be given. Further, if you are going to give the complete responsibility, even the safety and security and privacy, if they are going to do, that means the complete responsibility will be on them. So that kind of proper clear-cut legal agreement has to be done. So what are the checklist you should have when you are hiring a business associate or a subcontractor? First one is you need to do data mapping and check for whether they are DPDP compliant business associates and contracts are there. Hence, written data protection and privacy policy should be there. Agreement should be there. Role-based access and control of the data should be written in your hospital and also the business associates. Breach detection and internal reporting mechanism should be very, very strong within the hospital and also with the business associates. Staff training, either you are doing it or else these people who are supporting you with the software need to do, and what is their responsibility, liability has to be clearly documented. Data processing agreement, that is very, very important, my dear friends. Invariably, various hospitals may not have huge servers. That means they will be hiring the cloud. They will be hiring a third-party vendors for keeping the data. In such a scenario, you need to have a proper agreement, legal agreement. And you need to define the purpose and scope of processing the data, storing the data, prohibition of unauthorized access of this data by somebody else, whether they are DPDP compliant. If there is any kind of violation occur, how they are going to report to you, what will be their liability, what is retention and deletion obligations under the agreement, restriction for further subcontract. Imagine you have stored the data in a third party contract in a cloud and they are giving your data to somebody else to process. and restriction, and if they are doing it with your permission, who is that subcontracting person, what is their credibility, what are their DPDP. So all these need to be properly documented and agreement has to be signed. Further, all these business associates and the subcontracts breach management responsibilities need to be documented. Clear definition of what is data breach, immediate breach notification to you, containment mitigation responsibility, reporting to the data protection board, reporting to the patient, communicating with the patient, supporting for the investigation with the data protection board. All those need to be documented in the agreement, my dear friends. Further, ongoing monitoring and audit by your hospital and also all the subcontractors and the business associates. Hence, a periodic compliance review, not only within your hospital, and also you should be able to do the review of the significant processors. You need to get the access of their logs, activity monitoring, documentation of corrective actions if they have taken, prior written approval for subcontracting, allowing somebody else to process it, flow down of DPDP obligations written, clear accountability chain, and also right to audit the subcontractors contracts anytime, any place, so that they are open for you the whole thing. Finally, liability and indemnity is a very important clause, my dear friends. Hence, vendor liability for breach caused by them and their staff, indemnity for penalties, remediation and legal cost, financial penalties defined very clearly, termination of rights for serious or repeated breaches. Those have to be done. Further, exit and data disposal, my dear friends. Once the contract ends, imagine you have a contract with the cloud services for 5 years. After 5 years, there is no contract, but you need to have a contract that secured return or deletion of all personal data, certification of deletion, post termination of confidentiality obligation written very well, post exit audit rights has to be there, my dear friends. Those person should not say that there is no contract now, I will use all your data as I want. So these kinds of proper legal documentation and post exit of the contract clearly written, and who owns the data, all those needs to be properly documented, my dear friends. Hence, all your business associates, contractors, subcontractors, your medical devices, softwares, hardware should be DPDP compliant. If they are not compliant, don't do business with them, my dear friends. Otherwise, they are going to go down because of DPDP violation. They will also bring you down. So now let's critique about this DPDP Act and rules. Of course, this is one of the best, DPDP Act 2023, and also the rules. But however, if you look at the research from Western country, for every patient to secure the data in a digital world, it costs somewhere around 150 to 300 US dollar per patient per year, my dear friends. Even without even seeing the patient, for data compliance, you have to spend minimum 7,000 to 14,000 per patient. This will cost. Further, DPDP Act 2023 is not comprehensive for healthcare data. One way is to solve this by having a separate DPDP healthcare rules, my dear friends. Many of the healthcare professionals across India are requesting for a separate DPDP healthcare rules. Further, penalty should be decreased for healthcare professionals for simple reason. Otherwise, many of the individual doctors who are providing services in the rural area, semi-rural area, semi-urban area, or in the district places, they will not be able to be DPDP compliant. The simple reason is the cost is very high managing these digital personal health records. In such a scenario, we have to make a different ecosystem for them. Further, individual clinicians can consider going back to pen and paper records for a time being, Once the DPDP Act evolves, they can consider going back to the digital personal data protection. Cost of healthcare will definitely increase, my dear friend. Having a consent manager, having a data protection manager, DPDP Act compliance cost will be transmitted to the patient. That means invariably the patient cost will increase by 2 to 3 times, either OPD or inpatient. Further, can this government hospitals, primary healthcare center, community healthcare center, district hospital, will they be able to do DPDP compliance? Or else these hospitals will not do, and the patient who are accessing this government hospital, their data can be breached. These are the questions we need to answer. Invariably, the government data breach are not responsible. Invariably, this becomes a farce exercise, my dear friends. To overcome this, the government has come up with a brilliant creating the Ayushman Bharat account, ABA number, my dear friends. Every citizen can create digital health mission under this, a separate ABA number, that is Ayushman Bharat health account. Under this, they can store their data. But however, this is not robust for all healthcare needs of a patient. This can be upgraded, made available for freely to the patients and also to the doctors across the country. And it should be made available even in the rural area. If it is done, then the digital Personal Data Protection Act can be implemented. Otherwise, it will be very costly affair, my dear friend. Although the law is excellent, but invariably the implementation become very poor. To conclude, this is a well drafted legislation, but the huge cost is going to be on the healthcare professionals and clinical establishment. Hence, how it will be implemented is a big question. But every clinical establishment doctor should learn about DPDP Act and how they can be compliant with the digital personal data protection. Although this law has been able to balance between innovation and regulation, but the balancing act of the cost is not been very clear, my dear friends. But however, the DPDP Act is very good, and the Digital India mission regarding this is a very positive step. But how it will be implemented is a big question. But remember, 2027 May 13th will be the date the DPDP Act will be implemented across the country, and every healthcare professionals and clinical establishment acts who are using digital data for providing care needs to be complied with this law. Thank you very much for giving your valuable time. Stay safe.